Why would a jury hear expert testimony about danger when the person killed was asleep? That question sits at the center of a Pace Haub law blog post about battered woman syndrome, self-defense, and one of trial advocacy's hardest jobs. This is not really a policy debate. It is a courtroom problem. And for trial lawyers, the lesson is clear. When jurors think behavior makes no sense, the case can turn on whether counsel gives them a framework. The article opens with Judy, a woman abused for decades who shot her husband after he threatened to kill her and then fell asleep. For a jury, that fact pattern creates instant friction. The shooting happened after the immediate attack stopped. The defense still has to explain fear, reasonableness, and timing. That is where battered woman syndrome entered courtrooms. The theory, developed by psychologist Lenore Walker, tried to explain patterns jurors may otherwise misunderstand. Walker described a cycle of violence. Tension builds, abuse erupts, then comes apology and calm. The pattern repeats and can trap a victim psychologically. The article says lawyers use that framework to support self-defense in non-confrontational homicides, where the killing happens during a lull rather than during active violence. For advocates, the teachable skill is simple. Before arguing law, counsel may need to teach human behavior. A case theory without a behavior theory can collapse. According to the article, battered woman syndrome is not a separate defense. It is support for a self-defense claim. That distinction matters at trial. The lawyer is not asking for sympathy alone. The lawyer is trying to make the defendant's perception legible to jurors. The legal pressure point is imminence. Traditional self-defense asks whether the threat was imminent and whether the belief in danger was reasonable. In federal courts and many state courts, judges screen expert testimony under the Daubert framework for reliability and fit. That gatekeeping role can decide everything. Cornell's Legal Information Institute explains that judges look at testing, peer review, error rates, standards, and acceptance in the relevant field. So the trial skill here is not just direct examination. It is expert foundations. Qualifications, methodology, limits, and relevance must all be built cleanly. Think of it like handing jurors a map in a blackout. The map does not decide the verdict. It helps them navigate facts that otherwise feel disorienting. The article contrasts two outcomes. In one California case involving Robin Elson, the jury heard extensive evidence about her mental state as a battered woman. There, the reported facts included years of abuse, threats, and a gun pressed into her chest before the husband later slept in a chair. Robin Elson was acquitted of murder. The article presents that case as an example of how expert framing can help a jury understand subjective fear. Then comes State v. Norman from North Carolina. There, the article says, the court held that a sleeping victim did not present the legal imminence required. That is a devastating trial lesson. Sometimes the fight is not over credibility. It is over whether the jury even gets the instruction you need. So lawyers should ask early, what legal doorway must the evidence unlock? If the theory depends on expert testimony, build that record from day one. The article also takes the critiques seriously. Scholars like David Fagman argued that battered woman syndrome rested on weak empirical foundations and problematic methods. That critique matters because a skilled cross-examiner will attack science where doctrine depends on science. Weak methods invite exclusion, limitation, or impeachment. At the same time, courts and commentators have recognized a practical problem. Many jurors carry myths about why victims stay, return, recant, or minimize abuse. New Jersey's State v. Kelly became a landmark because the court recognized that expert testimony could help jurors understand a battered defendant's state of mind. The National Institute of Justice has also highlighted that women are far more likely than men to be killed by intimate partners. The same body of research identifies risk markers tied to lethal outcomes, including prior violence, recent attacks, frequency, stalking, and strangulation. For trial lawyers, that means preparation has to be sharper than labels. Do not rely on the phrase battered woman syndrome alone. Tie facts to observable risk. This is the real advocacy lesson from the article. Expert testimony works best when it translates behavior, not when it substitutes for proof. A strong lawyer would connect the history of violence, the defendant's failed attempts to leave, specific threats, escalating danger, and the legal elements jurors must decide. A weak presentation sounds abstract. A strong one sounds concrete. What did she experience? What did she believe? Why would that belief make sense here? That approach also respects the limits of expert testimony. The expert can educate the jury. The jury still decides what happened and what it means. According to the National Domestic Violence Hotline, leaving an abusive relationship can be a period of heightened danger, which helps explain why escape is not simple. So the practice point is this: when a case involves counterintuitive conduct, prepare to teach before you persuade. Next time you prep an expert, practice a direct that turns theory into plain English and ties every answer back to an element the jury must decide. Practice that skill with AI-powered courtroom drills at trialtutor.com. And if this breakdown helped, like, subscribe, and share it with another trial lawyer.